It looks good. I will let you mute. So can you see everything?
Yep, you're all good.
Okay, perfect. Well, thank you. As Phil said, my name, of course, is Jeff Kunkler. I'm not with Everhart, but I'm with Carlisle, Patchen and Murphy. There are a couple of disclaimers. You can't go to a presentation from an attorney and not have disclaimers. I'll try to keep them brief. The first is that, as Phil mentioned, we are an Ohio-based law firm. So I'm sitting in our Grandview office. We also have a Dublin office. I'm only licensed in Ohio. I do realize the Everhart network expands much beyond that. And so many of you may not be Ohio residents. That being said, almost all of our laws in this area are very similar from state to state. But if you have a very specific state related question outside of Ohio, I may or may not be able to answer it, but certainly feel free to ask. And then second, nothing that I'm giving today is any direct legal advice. And if you have questions, as Phil said, the best thing to do is as you're thinking of them, type them in the chat, and then we'll read through as many as we can at the end of the session and try to answer them for you. It would be best to put them in, but since we already have, I think we're 51 people already in, and that number is growing. So since we have so many people, I don't want to detract from the content by answering them as we go. So we will field those at the end. With those two brief disclaimers, I will jump into it. You're here today to learn about Estate Planning 101. Real quick background on me and the firm. So our firm is what you call a full service mid-sized law firm. Basically means we've got about 36 lawyers and we do whatever you think lawyers do. So if you walked into my office and needed to deal with a tax issue or real estate or a family law issue or a lawsuit or whatever it is you need, someone here probably does it. My little specialty is I've spent almost 15 years now just doing estate planning. So I work primarily with individuals, couples, and families to lay out who makes their decisions if they're in an accident, and then, of course, what happens if they pass away. Today's topic, Estate Planning 101, is sort of building the foundation to your plan. Let's get the key documents in place that everyone needs. So we're going to talk about some powers of attorney, wills. We'll talk briefly about trusts. The goal here is really just to identify, what do you have? Do you need something else? Do you have family members who need something else? And kind of go from there. And if you do have questions, like I said, please put them in the chat and we will get to those at the end. Without any further ado, I'm going to jump right in. This is a ton of content. The slides were already sent to Everhart. So if I go through this too fast, that wouldn't surprise me. I talk quite quick, but you can digest the slides at your own speed. Just ask Everhart for them and they'll give them to you and you can take notes, ask questions, etc. So if we're going to talk about estate planning, the first thing there in the first half is your estate. Well, what exactly is your estate? At a super simplified level, it's really just a balance sheet. So we take a look at your assets on one side of the ledger and your liabilities on the other. And if you pass away, we have to wrap up both sides of that column. On the asset side would be your possessions. So you've got bank accounts, your 401k with Everhart, you've got perhaps some investment accounts, some real estate, a car, bank accounts, etc. Your debts are on the other side. So you've got perhaps a car loan, mortgage, student loans, credit cards, any sort of debt would be on the other side. And then if I'm wrapping up someone's affairs, whether they have a will or no will, I have to report the assets and the debts and we sort out who gets what. So for an incredibly simplified example, if I was working with the family of Joe who'd passed away and at his death, he had a house and a car and a checking account, those would be his assets. I would list those on what's called his inventory. And if Joe had some debts, and specifically in this case, a mortgage, that would be on the debt side. So his net estate would be the assets less the debts. And there's some very simplified math here for you to view as well. How do you plan for an estate then as the next sort of logical question? First and foremost, we try to make it as efficient as possible. So most people who come to me have some desire that their spouse or their kids or their charity or whoever they want to get the stuff gets it as quickly as possible. They don't want things tied up in court or with the IRS for months or years. And they generally want it to be efficient, meaning we want to minimize costs. They want to get as close to 100% of their estate as possible to the people or organizations that they care about. They don't want to lose money to the court, to the IRS, to the state they live in, to the executors, et cetera. So we try to make that as efficient as possible. If you happen to be one of the people on the call who owns the business that you work for, we may need to figure out what happens to that business. Do you have a key employee you can take over? Would it need to be sold to a competitor or something along those lines? That can become very important if you are owning a closely held asset like a business. And then certainly when possible, we try to reduce estate taxes. Taxes are probably the least exciting portion of today's content. But I will go over the Ohio inheritance tax since that's where I'm based, give you some hints about other states, and then talk about the federal estate tax as well. The spoiler there is most of us probably don't need to worry about the estate tax this year, but I'll still tell you what the rules are and how you might be able to plan for those. So when it comes to estate planning, the sad reality is most people don't have anything in place. If this wasn't Zoom, if we were in person, I'd ask for a show of hands who has a will at least or powers of attorney. And what I typically get, because I do a lot of these presentations, is roughly half the people in the room have done something. And that's pretty consistent with what the stats bear out, that almost 2/3 of Americans don't have a last will and testament in place right now. And that things have actually gotten worse in the last 15 years. It was about 57% back in 2011. And there's an article from Forbes that I borrowed this from. And why I like this article is because it asked the follow-up question, why don't you have an estate plan? And they summarized it sort of Family Feud style. I like game shows, Family Feud being one of them. And so they said, if you don't have a plan, what's the number one answer for it? So Steve Harvey's doing the surveys. And what the most common answer to why people don't have a plan is that they just haven't gotten around to it. I hear this all the time. I have a huge number of people who walk into my office and say, I know I needed to do this at some interval when I got married or when we started a family or when I bought my first home. But, it hasn't been top of mind, hasn't been a priority. It's been on the back burner. I will say there's no harm in getting your plan done sooner than later. And there is extreme harm on the other side. If you are disabled or pass away and you have no plan, I don't have an opportunity to go back and put one in place. And so it's always better to knock this out on the front end, even if that means you make some updates every few years. The second most common answer was they didn't feel it was that urgent. Hear this a lot as well. I don't have any particular healthcare needs or diagnosis. I'm not dying tomorrow, so I'm not going to worry about this. Again, unless you have a pretty specific circumstance and you know when you're going to pass, we don't have the ability to look in that crystal ball and see when that date is. And so you have to do it sometime in advance. The further in advance, the better, generally. That way you can really think it through and take care to make sure you've made the right decisions. The third most common answer, people didn't think they needed a will. I hear this a lot from people who are either not married or don't have children, that it's just not that important. The reality is, for single people and people without kids, it might be even more important to do a will because the law in every state makes some assumptions. If you don't have a will, they sort of guess who you'd like to leave your property to. And that works better for married couples and people with kids generally. If you don't have those, then it gets a little strange. And I'll give you some examples of what would happen in Ohio if you didn't have a will. 14% of people just didn't want to think about death. That is a reality we face. People tell me all the time they didn't want to call a lawyer because they didn't want to have these hard conversations. The reality is it is difficult. I'm going to ask questions like, what do you want to do if you're in a really bad accident? What if your spouse is in that same accident? What if your kids are in that same accident? So you do have to go through an uncomfortable thought process, but I will say there's an incredible sense of relief. My clients who go through this and take a couple of tough meetings and make some hard decisions are so grateful when they get to the finish line and say, I don't have to worry about that anymore. I've now laid out who makes the decisions for me. Who should have a plan? And I will say at the end of this presentation, I've now created what I call the estate planning life cycle. So people used to see this and they'd get to the end and they'd say, that was great. I don't know what I need. Can you distill it down? And so that's sort of at the end of the presentation. But in terms of who should have a plan, anyone over 18, whether that's you on this call or perhaps you've got kids who recently became adults, should have at least the basic documents in place. It doesn't really matter how large or small your estate is. The same documents apply to everyone, at least at the basic level. So every adult should have healthcare and financial powers of attorney, advance directives, and a last will and testament. And it doesn't matter whether you've got $1 to your name or 100,000 or $100 million. You still need those documents to lay out who makes your decisions and where they go. Certainly the larger their estate, it might get more complex. Maybe we use trusts, maybe there's some tax planning, but even a small estate needs some help. I donate some time to something called the Legal Aid Society here in Columbus. And that organization links me with low-income seniors who need to lay out their last wishes. Even though they have almost nothing to their name, it's still important to say who wraps up their affairs, who manages the funeral, those sorts of issues. And last but not least, if you've been through these sort of big events, that would be a time to either create your first plan, or if you have an old plan, it probably is a time to relook at your plan. So big ticket events. If you've been married, you probably want to include your spouse as a decision maker, probably a beneficiary. On the other side, if you've lost your spouse, you're going to need to update everything because your spouse is probably your power of attorney and your executor and your beneficiary. If you've been divorced, that's two people who need new plans. You probably don't want your ex making decisions for you or receiving your property. Anytime you have more kids, always an opportunity to add them to the plan. If you get an inheritance from parents or grandparents, is a good opportunity. If any of the people you've named die, whether that's your power of attorney and a decision maker or it's a beneficiary, you're going to have to fill in someone for them. And then similarly, if you move to a new state, our advice is to meet with someone locally who's a lawyer in that jurisdiction who can tell you, does this plan work perfect? Or perhaps do you need to update some or all of it? The laws are pretty similar, but it is best practice to talk with someone in the state where you reside in terms of whether those documents are sufficient or not. The big benefits to planning in advance: you maintain a lot of control, and we'll give you some specific examples on the next couple of slides. There might be tax savings. There's a number of strategies that have to be done in advance in order to save money. And so that if you're trying to save money on the estate tax or capital gains, for instance, you want to plan in advance. A lot of people come to me and they try to avoid probate. So they say, when I die, I don't want to go through the court. Either I've heard stories or perhaps I've had a loved one go through it. It was very slow, often very expensive. And so many people want to minimize that. And a good estate plan can minimize or perhaps even completely avoid going through the probate process. There might be some protection, whether that's your own for long-term care planning or for your kids if they've got disabilities or they're not good with money. You may want to protect your assets from certain types of liabilities. And then the last few are kind of the same. So giving some guidance to the family. Who do you want to be your decision maker for healthcare versus finance, so on and so forth. The main reasons to plan now, like we talked about, are the control and all those issues. The types of control you can have. First and foremost, who makes your healthcare decisions? And there's a specific document for that we'll cover on the next slide. A second job is who makes your financial decisions. So if I'm in an accident and I can't talk to my doctor, that's one person, my healthcare power of attorney. If I'm in an accident and I can't talk to my accountant or to Everhart or to me or something along those lines, you may have a different decision maker for finances. Perhaps it's the same person. You pick the best person for the job. And then you also get to pick who gets your property. Is it equally to the kids? Do you want to factor in your church or charity or other causes? Is it not going to your family at all? Maybe it goes to a caretaker or a friend. That's all things you can do with a plan. And then if you're like me or Phil and you've got little kids, the estate plan is also where you say who would raise them. So one of the most important things for parents like us is that your documents say, if I die and my kids aren't adults yet, who would I like to raise my kids? There's a million considerations there. Should it be grandparents? Should it be people in the same school district? I give people advice on this all the time, but really important, who would actually raise your kids if you pass away? And then last but not least, who's going to wrap all this up? Some people come in thinking it has to be your oldest child. That does not have to be the answer. I want you to pick the person who's responsible. And then depending where you live, you may want to pick someone local to wrap up your estate as well. And we'll talk about that with the benefits of a will here in the next couple slides. The common documents you're going to see, and the names of these may vary slightly from state to state. Pretty much everyone calls it a durable general power of attorney, and we'll cover that next. And then these are the two that could be combined or separate depending on your state, but you also have the right to say who makes your healthcare decisions. In Ohio, we call it a healthcare power of attorney. That says if I'm in an accident, who makes my decisions, and we have a separate living will that relates to end of life decisions. A lot of states combine those. So we do documents for people all over the country, and I'd say most states combine these documents, but you need to see what your state has available and work with what they make available. And then sort of the fourth key element of an estate plan would be your last will and testament. At a minimum, this is the starting point and what you need. You may or may not need anything else. It really just depends on the circumstances of your family, your assets, your wishes, your goals, etc. For some people, they may use a trust, and we'll cover those briefly this morning. We won't dive too far into them, but I'll hopefully give you enough information to identify, should a trust be a part of my plan or do I not need one? And it really, like I said, just depends on your individual facts and circumstances. Covering those in order, the first was the durable general power of attorney. This is what most lay people just call a financial power of attorney. Those words at the top do mean something. And what most people want to have is that durable and general form of this. So the concept of the power of attorney is you appoint someone else to manage your affairs for you. The term durable would mean that the document lasts even if you're in an accident. So on the proactive side, if I'm working with someone who's young and healthy and working, they want a document that says, if I'm in an accident, someone takes over my affairs. And a durable power of attorney is one that will keep lasting even if you're incapacitated yourself. So you definitely want durable. And then general is the one you do proactively. So a general power of attorney has a long list of stuff the person can do. They can deal with your taxes and your car and your house and your investment accounts and your bank accounts and your digital assets and all kinds of different stuff. The point in doing the general one is you don't know when someone's going to have to step into your shoes. So in advance, you're saying this person has general authority to manage my affairs. Occasionally, we'll do a specific power of attorney saying, I'm out of town on this day and I need someone to complete this transaction, to buy a house or to go to the bank or something. So you can do something specific, but those tend to be more one-off, limited use. What most people want is the durable general type. And then the big benefit of doing this is that if you've said in advance, this is the person who can manage my affairs. If you're unable to manage your affairs, I don't have to go to court and have a guardianship appointed. So the alternative that's incredibly more time consuming and expensive is that if someone's in an accident and can't pay their bills or file their taxes, I could go to court where they live and say, Jeff's been in an accident. He can't manage his affairs. You need to appoint someone to be in charge. But a guardianship typically involves going to the court, having a hearing, and your costs are going to be, tens of times higher than they would be to have done this in advance. And so you really want to have this sort of in your list of documents and your quiver of tools that you have available for your family to use. The second temporary, what I call disability document, is for healthcare, and this is the one that could be combined. In Ohio, we have a separate healthcare power of attorney. The concept is very similar. You say in advance, if my attending physician says I can't communicate effectively, so I'm incapacitated, whether I'm literally unconscious or perhaps on pain meds or have a cognitive issue, then I get to say who makes my decisions for you. That can be a spouse, that can be a child, that can be a family member, whomever you'd like it to be. And it does avoid the need of a guardianship. Many states have these publicly available. So here in Ohio, if you Google Ohio Healthcare Power of Attorney, pretty much every hospital system will have this on their website. You can simply download and fill it out. That is perfectly fine. Almost every state we deal with when I have clients who move around the country or whose kids move around also has public forms available. So wherever you live, you can probably find this one pretty easy, but it's an important one to have. You ought to say in advance who makes your decisions. If you don't, then again, we have to go to court if you're in an accident. The other half of healthcare is the living will. And a living will or advanced directives governs life support in certain circumstances. Again, most states have a standard form. The one in Ohio has become standardized and allows people to say in advance, if they are permanently unconscious, terminally ill, and there's no hope, they may not want their wife, their kids, other people to have to make the pull the plug decision. And so what this document allows you to say in advance is if I'm in a certain condition and if there's no hope, and if two doctors agree there's no hope, I want the medical staff to remove life support and allow me to pass naturally. I do not want the burden of that difficult decision to fall on my spouse, my kids, my caretakers, etc. This one in most states is optional. I would say the vast majority of people, once they think this through, choose to do this document, but it interacts with the healthcare power of attorney, or even in a lot of states, like I said, would be a part of that actual document. Those two or three, depending what state you live, so the financial POA, the healthcare POA, and maybe the living will, those are the disability documents. Every adult needs those. They tend to be pretty standard, but that doesn't mean they're not important and that you all shouldn't have one. The other sort of key documents as a part of a plan is what happens if you pass away. And the starting point is what we call a last will and testament, which serves three main purposes. Purpose one, it says who gets your stuff. Is it equally to your kids? Perhaps it's very granular. I have people who say, I want the house to go here and the car to go here and this account to go there, but it says who gets what in the event of your death. Depending how old you are, I typically like percentages or fractions because we don't know what you're going to have necessarily when you die, but some people do get very specific. I want this amount of money to go here and this amount to go there. Second purpose of your will is you name the executor. This is the one who follows the rules of the will. Does not technically have to be a beneficiary. The will could say, I leave it to, my child A and B, and I want person C to be in charge. Person C is the one who would actually sell your house and your cars, turn in the will to the court, do all of the paperwork, etc. They don't have to be a beneficiary. Depending on your state, you may want someone who lives in the state that you reside to be your executor, but that does vary a little bit from state to state. Here in Ohio, the court does have a preference for someone to live in Ohio. You can avoid an expense of getting what's called a bond posted if the person lives in the state that you live in for a lot of places. And then third, and most important for particularly if you got little kids, the will is where you name the guardian. So you write in there, if I've died and my kids aren't 18 yet, this is who raises them. You can also do that for a child with a disability. So you could say this child is over 18, but I'm their guardian and I nominate a successor guardian so that if I pass, this child with a developmental or other disability would still have someone who's nominated to raise them. If you don't name the guardian, the court's going to appoint your closest relatives, which may or may not be the right answer. So we always recommend, if you know who you want it to be, that you put it in your will, and that if you're the other parent of the child, ideally would have the same answer in their will as well, so we don't have a timing issue. The power of attorney for finances in a lot of states can also include a guardianship nowadays, which is important too. So that would be a good question to ask when you're preparing your plan. There are some big advantages of having a will versus doing nothing. The first big one is there that nominates the guardian for the little kids. Like I said, if you don't nominate a guardian, the court in most states will contact all of your next of kin. So your closest relatives will be made aware that there's a guardianship proceeding, and they'll all have the same right to raise them. So that means you're going to have, both sets of grandparents and all the aunts and uncles probably fighting over the kids, whereas you could have picked this set of parents or siblings or friends or whomever you'd like it to be. Second big advantage, you get to pick where your property goes. If you don't have a will, the state where you live decides who gets your property, and they generally just look at your family tree and pick the closest relatives. They don't actually ask who were you close with, who you were estranged from, etc. Third, if you want to make bequests, so if you want to say, I want this item to go to this person, or if you want to leave something to a non-family member, that's all permissible with a will. You can write a will saying, I want this car to go to my grandson. You could also write a will saying, I want a chunk of money to go to my church or something along those lines. That only happens if you have a will. If you don't have a will, the state's never going to leave specific items to people, and they'll never include a non-family member as a beneficiary. So that rules out all of your charities, your friends, your caretakers, etc. It also saves a lot of time and expense to have a will. So wills these days have gone from 1 or 2 pages 20 years ago to 5, 6, 7, 10 pages. A lot of the reason is that we put a paragraph in the wills now saying, I give my executor permission to sell my house and my car and file my tax return. By having those paragraphs, you don't have to ask the court for permission. And so it can save a lot of time and expense to be pre-authorized to dispose of the real estate and the tangible property and the vehicles, etc. If you don't have that, you basically have to ask the court for permission for everything. So when we have an estate with no will, it's not uncommon to have to go back to court over and over again to permission to sell car one and car two and the boat and the house and all the different things the person owned. And then finally, your will also allows you to name your executor. You can name anyone you want to serve that role. In Ohio, if you don't name an executor, then the court's going to appoint someone called an administrator. Very similar authority, but the biggest difference here is the administrator would have to live in Ohio. So while the court prefers an executor to live here, you could pick an executor anywhere in the world. If you don't have a will, then you're stuck with someone that lives in Ohio. So it's not uncommon that someone passes, there's no family here, so they're ineligible. They cannot serve as the administrator, and then someone in Ohio, which often becomes a lawyer like me or someone at another firm, ends up wrapping up their affairs because no one in their family has permission and the authority under the law to serve in that role. Without a will, there are a few neat things you should be aware of. First and foremost, the state where you live picks who gets your property. We call those intestacy laws, and they are first based off your marital status. The laws don't generally look at, are you separated, are you getting divorced, etc. You're either legally married or you're not, and that determines whether the spouse is included. This is mostly a joke, but you can leave nothing to your spouse if you plan properly. You're probably better suited to go to a divorce attorney and separate things that way than trying to do it through some crafty estate planning, but technically possible. Without a will, these are some Ohio examples, very similar in other states. So here, if you die with no will and you don't have a spouse, but you have kids, the court sort of assumes that you'd want to leave things equally to your kids. May or may not be the right answer. If you've got no spouse and no kids, this tends to be not necessarily the right answer, but they would actually leave it to your parents if they're living. I have a ton of people who say, well, mom and dad either don't need this or they shouldn't get this because they're in a nursing home or something. But the closest relative in Ohio without a spouse or kids is technically parents. After that, it becomes your siblings. If you don't have siblings, it's nieces, nephews. If you don't have any of those, then we have to pull out this chart. They call it the table of consanguinity, but there's a chart that shows us, if you go back to the grandparents' generation, it goes to aunts and uncles and then cousins and then second cousins, and you compare who the closest relative is. The court will try to find the closest relative. If they can find anyone, that person gets everyone of that class. So every second cousin splits the estate. You may or may not be close to these people or want them to get your stuff, but they get it because of familial relation. And then if the state can't find any relative, the state actually receives the property. We get these every now and then. There was a big one in New York a few years ago where an art collector passed with no family. They couldn't find anyone in the state of New York, got this millions and millions of dollars worth of art and other possessions because the guy had no will and didn't have any family. And so the state actually recovered that property. So for people without family, it's even more important to leave their will because they almost certainly don't want to leave it to their state. They'd rather it went to a friend or a worthy charity or something along those lines. If you're married, things are a little more confusing here. So if it's what we call sort of a natural or traditional family unit, meaning you've been married once and the only kids either of you have are the product of that marriage, and you die without a will, then they assume you want to leave everything to your spouse. If you've got a blended families where things get a little stranger, they want to make sure that the step parent does not cut out the step kids. So they try to protect the step kids. So here, if you die and you had one kid from before your marriage and no will, they would leave half your property plus 20 grand to your spouse and the other half to the step kid to make sure that the spouse doesn't ultimately cut out the step kid. And if you've got two or more kids, they only leave a third to the spouse and the other 2/3 go to the kids, but the spouse gets a bonus 60 grand. And doing some number of thousands of these, no one has ever wanted their will to say what that says. But it's what our legislature came up with. And every state has some version of this that figures out what do we do if someone dies without a will? Because unfortunately, so few people have wills. With it being almost 2/3 of society, there's a lot of people who pass without it. And we got to figure out what to do with their stuff. And this is what we've got. The simple solution is you can do your own plan, leaving your property essentially wherever you'd like. How you actually own your property is also very important. So I'm going to pause for 1 second on the wills and grab a sip of coffee. But the way you own your stuff is going to make a big difference on how it actually passes. And so this is sort of my do-it-yourself slide. You can use a lot of these tips to do your own planning, maybe in conjunction with someone like me, or maybe entirely on your own. So the first thing to understand is that whatever your will says would only control property as a part of your estate and goes through probate. The property that's subject to probate is easier to actually work backwards from than to define on its own. And so we're going to start with what is not probate property. So the first thing that wouldn't go through your will would be anything that you own jointly with a magic term called rights of survivorship. So if, for instance, you have a joint bank account with another person and you die, that bank account will go automatically to the survivor. So very common for married couples to go from spouse one to spouse two. That's great. Spouse two, when spouse one dies, doesn't have to file the will or go to court. They just get the checking account, the savings account, etc. A lot of people own their primary residence in this manner as well. If spouse one dies, it goes to spouse two. We don't have to file the will or go to court. A great tool for jointly owned property. Great for spouses, not as great or even really recommended at all for anyone other than a spouse. I don't generally want you to jointly own your property with your kids or other folks because the joint owner's liabilities become your problems as well. And so I don't want to expose you to the risks of divorce and credit and lawsuit and all the things that the other joint owner might have. But for a spouse, you're probably exposed to those anyways and willing to live with that. Second thing that doesn't go through probate would be anything with a beneficiary. So your retirement plan with Everhart, as long as you have a beneficiary, it goes directly to that person. So as an example, my will could say I leave everything to my wife, and if not my wife, to my daughter. But if my life insurance or my 401k leaves it to Ohio State would get that policy and it would not go through my will to my daughter or to my wife. And so great tool to use your beneficiaries on your 401, your life, your retirement accounts, etc. But it needs to say what you want it to say. Usually that's whatever the will says. It doesn't have to be. You could choose, I'm going to leave this policy here, and instead I'm going to leave my will here. But I want you to be thoughtful about it, and reviewing your beneficiary should be a part of your estate planning exercise. And then the last category is anything that's either POD'd or TOD'd, which stands for either payable or transferable on death. These are mechanisms that you can add a beneficiary to almost any type of asset in the world. Payable on death is for financial accounts. So for a lot of CDs, money market accounts, those types of things, you can go to the financial institution and say, I want this money market to be payable to this person or these persons upon my death. That is effective to avoid probate and goes directly to those people. And then transferable on death is generally for more physical possessions. So that would be a vehicle in a lot of states. Ohio is one where you can do a TOD on a car. You can also transfer on death a lot of real estate. It's not quite all 50 states yet, but the vast majority of states also allow you to file a transfer on death with your county saying, if I've died, I want this house to go to my kids or grandkids or charity or wherever you'd like it to go. So those are all great tools to be used in conjunction with your will. And like I said, a lot of people use this for some sort of do-it-yourself planning. Those basics, so the disability documents and the will, are sort of the foundation of an estate plan. Everyone needs those. Now we're sort of drifting into the more optional space, and that would be trusts. Trusts are great tools. We use them for a lot of reasons. They may or may not be a good fit or necessary for you, though. So you definitely need the first half of the presentation. A trust, and again, this is the very high 101 level lecture on this, is simply a private contract between the person who creates it, which most states call a grantor. Some states call it a settlor. Generally, the person who puts the property in is the settlor, but because that's usually the same person, you'll see the term settlor in Florida. I just did some Maryland documents. They use the term settlor there as well, rather than grantor. But the person who creates it is half the contract. And then the person in charge is called the trustee. Many times, again, it's the same person. I've created my trust and I am the trustee of my trust, which is a contract between me and me. Doesn't have to be. You can have a third party trustee, whether that's a family member or a bank or something along those lines. And then the trust serves sort of as a will replacement. It will say who are the beneficiaries. During your lifetime, that's probably you. But it would say if you've died, does it go to a spouse or kids or a combination of the two, or perhaps to friends or charities or something along those lines? There are lots of reasons people do trusts and lots of types. The ones we're going to focus on today are what we call revocable. But the main two types are either one, you can do a will that creates a trust, and that's called a testamentary trust. So my last will says if I've died and a certain condition, if my kids aren't of a certain age, then I want you to create a trust. Because it's created through the last will and testament, it is the testamentary trust. Those words kind of tie together. Those I do see in some states. Here in Ohio, they are not recommended. In Ohio and in most states, we prefer what we call a living trust, meaning that you go ahead and create the document today. It is not a condition of your will. The reason you want to do that, in most states, testamentary trusts are subject to the probate court. And one of the main reasons people do trusts is to get out of the court, to cut down on their expense and their costs. And so in most jurisdictions, you're going to want to do a living trust, just meaning the document is created and exists at the time you sign it and not going to wait until your death. The one we're going to focus on today, like I said, is the revocable type, which generally means the person who creates it can make changes to it. For your planning for worst case scenario estate plan, that makes a ton of sense. I write it today and my life's probably going to change. And every few years, I'm going to go revisit my trust and perhaps change the rules for what happens to me, my kids, etc. There are types of irrevocable trusts. Usually there's a big trade-off with those. So you can't change them and they're sort of fixed, but in exchange for that, you're doing that for some reason. So the big ones we see, perhaps for tax planning, I'm giving up control of this, but in exchange, it's not included in my taxable estate. And then the other purpose, which is a different lecture we do here for Everhart Advisors University, is for long-term care or sort of asset protection planning. So people do use irrevocable trusts to try to qualify for Medicaid and other benefits while protecting certain assets. Different lecture, happy to talk about it offline. And that is another topic that's typically covered as a part of the content through EAU. So if you're interested in that, just watch when they do the next elder law focused one. But that would be one of the other use cases for an irrevocable trust. On the revocable side that we're focusing on today for Estate Planning 101, one of the first things you got to figure out is how to get your property into your trust. That's what we call funding. And that can happen in two main ways. The first is a trust can generally own anything you or I could own. So you could actually put your assets in your trust. So you could walk into your bank and say, I want this checking account to no longer be in Jeff's name, but to be in the Kunkler Family Trust, for instance. You could do the same thing with a car, with real estate, with investments, etc. The other option is that the trust could also be the beneficiary. So you could alternatively go to those same places or go to your 401k provider or go to your life insurance agent and say, I don't need this account in my trust today, but if I've died, then add it to my trust because my trust says how to divvy it up amongst my beneficiaries, who gets it at what time, for what purposes, etc. But one of the biggest things you need to do is if you've created a trust, you need the assets to actually be in it or point towards it. Otherwise, it doesn't hold any weight or value, and it was just a waste of time and expense. If you're going to create a trust, you'll probably be your own trustee. You need a backup. What happens if you pass away? This is a lot like the executor role, but there are a couple of choices. Many people go with an individual. So perhaps you have your oldest child, or a sibling, or a parent, or some family member who can serve as in your absence. That could be because you're in an accident or because you've passed. Benefits of an individual: they probably know your family, your values, your goals, your wishes. They may also not charge much to serve because they're taking care of their grandkids or their nieces and nephews. But they might not have expertise in trust. This person might not have a degree in managing assets. They may not be a lawyer. They may not be an accountant. They may not be a financial advisor, etc. The other option is you can hire a company to do it. That's what we call a corporate trustee. The upside to a corporate is they typically have all those professionals on staff. So a corporate trustee probably has lawyers and accountants and financial professionals who can help do all of that. The downsides: they probably don't know your family. It's just an institution who doesn't necessarily know your values and goals. And then they typically also charge for those services, but very useful. I see it a lot in the context of a trustee that has to serve a long time. So if you're leaving someone to something to someone that needs to be managed, either they're too young or they've got a disability, or for some reason I need a trustee who's going to be around for 50 years. There may not be individuals that can serve that role, so it can be a good fit, and it's often a fit as a backup. If my family can't do this, then I've got some institution in line. So those are sort of your trustee choices. The reasons people use trusts are sort of varied. Because I like the Family Feud style, I've organized this slide into the most common reasons people come into my office and want to get a trust set up. By far, the biggest one is they want to leave things to kids who are not old enough to inherit. Most common for parents. I've done these for aunts and uncles, for grandparents as well. In most states, if you leave money to a minor, the state wants to make sure the money doesn't get misused. Here in Ohio, if you leave more than 25 grand to someone under 18, the probate court where that kid lives is going to oversee what happens to that until their 18th birthday. So you've now sent it to court, which is going to be expensive and time consuming and a hassle. And then in a lot of jurisdictions, as soon as they turn 18, they would hand the funds over to the kid. So many clients come into one, say, if I've died, I don't want my parents to have to go to court to pay for my kids' daycare and braces and travel. I'd rather it was private. And then two, I don't necessarily like 18. I'd rather this was held till my kids turn 21 or 25 or maybe even 30 or 35 or something. So by far the most common reason is to benefit people who are not old enough to inherit. Second most common is to protect privacy. Uh, Probate records in every state are public. And so if you want to see how much someone had in their estate or what their will said, you can generally access that. Ohio is going through a process right now where these are becoming online. Right now, I could email the court and get a copy of someone's will or their estate pretty quickly. Eventually, they'll be available to be downloaded online the same way you can look up your real estate records. So I have a lot of people who do not like the notion that whatever their private will said and whatever assets they have and whatever debts they had are made public. And so to avoid that, they do trusts because that's a private contract, not subject to public disclosure. Third, if you're leaving it to people who might be going through a credit problem, whether that's you don't like your son or daughter-in-law and you're worried they're going to get divorced, or your kid has a risky profession like a doctor or a lawyer or something, or in construction, or perhaps you know of a lawsuit, or they're not good with money, they might file a bankruptcy. You can protect your heirs from almost any benefit, any creditor type issue by leaving in the right kind of a trust. So I have a lot of people who set up a trust because they don't want to lose the money to a divorce, a bankruptcy, a lawsuit, etc. If you happen to have beneficiaries, whether it's kids or grandkids who are disabled, we can do special needs trusts nowadays. I do a lot of that work. I do a lot of work for the Special Olympics here in Ohio and have done a lot of estate planning for those constituents. There is a great tool that allows you to create trusts to benefit those who are disabled so that they can maintain their benefits, whether that's Medicaid, SSI, et cetera, but also have extra assets to supplement and add to what that's available. And so those are great tools as well. There might be some tax savings with a trust. We'll cover that a little more in a moment. And then last but not least, anything that goes through a trust doesn't go through probate. So some people do trust just to avoid probate. Um, Probate really varies pretty greatly from state to state and also county to county. So it would be important to understand where you live specifically, including as granular as the county. What does the process look like? Is it something you want to avoid? The answer almost always in Ohio is yes. We want to minimize or avoid that, but that's not necessarily true in every state. So you'd want to talk to someone local and see whether that's worthwhile or not. Taxes, and I said I'll keep this fairly brief. Good news for most states, Ohio included, is that many states have gotten rid of their estate tax. There's not one here in Ohio any longer. It's been gone for a few governors now. Governor Kasich helped repeal that. When I started my practice, pretty much every estate I dealt with here had to pay the tax, and that's because anyone who died with more than $338,333 paid Ohio 6% of every dollar beyond that, and then 7% above that. It's been gone for quite a while now. I don't see it coming back. Nationally, there's about 10 or so states that still have these, and it just depends where you live at the time of your death. Most states who have them just add on to what you owe to the federal government, but important to know, based off where I live, if I die, would I owe tax to my state or not? And it's just a decision based, it's just a test. Where do you live and how much money do you have? Are you subject to the tax? Federally, things are very favorable right now. So the current estate tax rules, and these are going to change in January. A few things you need to know. First, you can leave an unlimited amount to a spouse who is a U.S. citizen. So if you're two citizens married to each other, a husband or wife or any spouse can leave an unlimited amount to the other. So I can leave $1 billion to my wife if I want, and I don't pay tax. She's going to have to pay tax at her death, but you don't pay tax at the first death if it goes to your spouse. Second, the limit this year is that you can leave just about $14 million to anyone you'd like before you pay the estate tax. Anything over that has an incredibly steep tax. So if you have $14 million and die this year, the $10,000 that's above that limit is taxed at 40%. So $4,000 of those $10,000 would go to the federal government. So if you've got $20 million, you'd be staring down, a $4 million tax bill essentially. And so this is something you want to plan for if you're in that circumstance. There's also a principle that called portability that has been around since the Obama administration. This allows you to use your spouse's exemption and basically double the amount you have available. So for instance, if a spouse dies and leaves it all to their spouse, the surviving spouse can file a tax election and claim the unused portion. So you go from 13.99 all the way up to essentially 28 million instantly by doing that. I will note, until the big, beautiful bill came about on July 4th, we were going to have a lower estate tax next year. So it was going to go from this 13 million, it was going to get cut in half to roughly 7 million. The new tax bill that President Trump signed on July 4th increases it actually. So as of January, you'll now have $15 million per person you can leave to whomever you want. There will still be some indexing, so that'll start going up a little bit every year as well. Gift tax is one I get a lot of questions about. There are annual limits as to how much one can give away. This is another one that plays better as a show of hands if I'm in person, but it's actually the person who gives a lot of money away who pays tax rather than the person who receives it, which is a little counterintuitive. The rationale is if I'm sitting on 20 million and I know the limit's 14 million, they do not want me to give away $7 million right before I die to try to beat the estate tax system. So if you give a large gift, you actually pay the tax. Your limits this year are that any individual can give $19,000 to any other individual without filing a gift tax return. So that means you can give it to each of your kids. Your spouse can give it to each of your kids as well, or anyone else in the world. And that's a per year gift. So you can give 19 this year and you can do it again next year. Inflation has increased enough in the last few years that this has gone up roughly 1,000 or so a year every year for the last few years. But there's an annual limit. For a long time, it was stuck at 13,000. And then, like I said, it's been creeping up ever since. There are some strategies that you can use to increase that amount, but basically it's a per person, per giver, per recipient limit. And it's a federal limit. Most places don't have a state estate tax. So the tricks here, as I said, it's a per recipient gift. If you're married, you're allowed to do gift splitting. So even if one of the two spouses gives the entire gift, you can deduct, you can not count up to 38,000 if you're a married couple and both citizens. If you go beyond your limit, technically it just decreases what you can give at death. So if you give as a single person 20,000 away, you don't actually pay tax, but you do have to report it to the IRS And then the IRS will say you've got 1,000 left to give away at your death. Two important exceptions. If you pay directly for either healthcare or tuition, you can give an unlimited amount. You're not capped at 19,000, which is great if you're paying for someone who's going through really costly treatment, or for a kid or grandkid to go to college or something. The key is you have to pay directly. So you write that check to the university or to the hospital. You don't give it to the grandkid who turns around and gives it to those places. And then, as I mentioned, most states don't have a gift tax. It's just a federal rule. When it comes to estate planning, you generally want to have an attorney do this. There are some websites available with documents. I'm very skeptical that you've worked your whole life to amass whatever your nest egg is, and you're going to trust some printed form to do this. So certainly, I would consider at least consulting with an attorney. If you have a very simple plan, maybe you can get by. If you wanted to pick an attorney, there's a few ways. First, I would get someone who specializes in the area of estate planning. The practice has become incredibly specialized. Some people do still become a general practitioner and hang a sign, Jeff Kunkler, attorney at law, and I do divorces and domestic disputes and estate planning and real estate all at the same time. That's less and less common. A lot like medical practices, we're at our firm and at many firms, people are very specialized. So I'd get someone who focuses on this. If you don't know who to ask Everhart or your financial planner. Other suggestions: your life insurance agent or accountant, certainly friends, coworkers. I throw on family members and neighbors. I really can't imagine getting your mail and asking your neighbor who their lawyer is, but certainly you can ask, people in your town. I know there are Facebook groups where people give these types of recommendations. I live in Powell, which is a suburb here of Columbus, and between the Powell parents and I think it's called the Dublin Moms in the Know, I get a lot of leads from people who give our name out. So, you can certainly ask social media and other places for recommendations as well. And then you can always call your local bar association. Those are run by the jurisdiction. So there's a Columbus, all the major metros in Ohio have them. Most of them have some sort of referral list or program. So if you have nowhere else to turn, you could always look up your local bar association, ask them for an expert. In terms of fees, this is a great question to ask before you sit down. There are two main ways lawyers charge for this work. The old school way is hourly. It's like a taxi meter. I do have an hourly rate. And so if you're hiring me hourly and I spend, 15 minutes working on your case, then you get billed for 15 minutes of my time. People tend not to like that because they don't know what the total cost is going to be. And they're also worried that if they give an extra phone call or revision or email, it's going to cost them more money. So what many practitioners have done is gone to a flat fee, where if you need, powers of attorney and a will, it costs X. And if you need a trust, it costs Y. Clients tend to like that, so they know what they're getting into. And then the law firm, if they do enough volume, they absorb the risk that, some of them are very efficient and some of them take longer, but we do enough of them that they sort of average out throughout the year. My note here is to discuss that when you first sit down. I would say I would ask that before you meet these days. There are more and more law firms that are charging a consultation fee, meaning you're going to pay just to meet with that lawyer, whether or not you hire them to do anything. And so I don't want anyone to get surprised that, hey, I came to this talk, Jeff said call a lawyer, and then you get a bill for someone you don't want to hire. And so when you're scheduling your first consultation, which most of us are doing both in person and video these days, when you're scheduling that, I would clarify, is that complimentary or is there some sort of fee involved with it? And then top tips. So again, I have a lot of people come to this and say that was too much info. Is there like one page I could focus on? So I created this. If you're going to take nothing else from it, this is sort of the one page to print. Number one, plan for your disability. Do the healthcare POA. If your state has it, do the living will and do the financial POA. It doesn't matter how young or healthy you are, you need these things done in advance. And the same is true for your kids who are young adults. Once they turn 18, you can't make their decision. So when you send them off to college, make sure they have the healthcare and the financial POAs and perhaps the living will or advanced directives. Two, doesn't matter how big or small your estate is, big or small your family, you need a will. That's a starting point. You may or may not need a trust, but you definitely need a will. Third, if you got little kids, you need to nominate a guardian. The last thing you want is all of the family fighting about it when you're deceased, not knowing who you wanted to raise the kids. If you want it to be a non-family member, so if you want to pick friends in your school district or something, you absolutely need to put it in your will, because the court's going to only notify the closest family. They won't notify friends or other caretakers. Fourth, pick the best executor. It does not just have to be your oldest child. Pick someone who's good with record keeping and knows about tax returns and selling real estate and cars. They can certainly hire a lawyer like me to help them, but you want them to be pretty capable on their own to cut down on your expenses. Fifth, if you don't do a will, just realize that whatever state you live is going to pick where your stuff goes, may or may not be the right outcome. Six, if you got little kids, I would definitely think about a trust, particularly in states that supervise the probate process like they do here. Seven, even if you've created a trust, the way you own your assets is important. We covered this with the funding slide, but you need your assets to either be in your trust or pointed towards it for it to have any effect. Otherwise, it was a waste of time and effort. Eighth, as a general concept, when you're writing your beneficiaries, your estate shouldn't generally be the answer because that will go through your will and probate, which is probably part of what you were trying to avoid in doing some planning. So definitely think about who you want the beneficiaries to be. Ninth, I told you the current Ohio and federal laws for this year and even the federal laws for next year. I do not know the laws for 2027, 2028, or beyond. I also don't know when any of you are going to die, and you need both of those variables. And so you're going to want someone like me to tell you, based off where you live and what year it is, are you going to have taxes owed or not? And then depending on the size of your state, you may want to start doing some proactive planning in order to be able to reduce that tax burden at the time of your passing. And then last but not least, if you're going to give away the gift tax limits, I would certainly consult with someone first. If you're giving it away, there's probably not a way to get it back, and you may or may not have a need to file a tax return for it. So please talk to your accountant or your lawyer, or perhaps both if you're giving those large gifts. And then I mentioned this at the outset, and we'll get to Q&A. If you have no idea where to start, here are some suggestions. If you're single, there are some tips. In a relationship or married, you need some different things. Once you've got a family, there's some things you need. And then once you're in sort of the retirement or golden years. So on the starting side of that, when you're single, I would definitely do the disability documents. So strongly recommend the living will, the health care, the financial POA. And I would even do a will. Once you're 18, there's no harm. And more often than not, you'd be best served having it. Certainly by the time you're in a committed relationship, you have to check those boxes. You need those things. What does the spouse or significant other get or not get? If you're not married, it's even more important because the law won't leave things to a non-married significant other. You may or may not need a trust at that point. I would think about it, but you probably don't check that box yet until you start a family. Once you've got kids, you've got little ones, you need to figure out at what time they inherit, who's in charge of it, who raises them. That's where you probably add the trust to the mix. And then you start talking more specialized stuff. Do you have sort of generational wealth that we can plan with a dynasty trust? Is there anyone in the family with a developmental disability? Do you need a special needs trust for some reason? If you hit retirement, if you need them, you would have checked those boxes. And then you start thinking more long-term care. Have I saved enough that if I go to an assisted living, independent living, nursing home, I can pay for that care? If you haven't, there are options. Some people look into long-term care insurance. Some people just try to save enough money through financial planning. Other people try to use trusts and get assets out of their name. And so if you want to look into long-term care or elder law planning, that's a good conversation to have sort of post-retirement, given this is mostly people who are working at companies affiliated with Everhart, probably not on your radar yet, but as you're getting close to or shortly beyond retirement, that's something to think about. And then you may want to put your life insurance into a special trust to avoid estate tax as well. But again, conversation for much later in life. How to get started. It's a team sport. You're going to want a CPA, a financial planner, your insurance agent. I would include funeral planning in that conversation, and then someone like me, an estate planning attorney. And then for upkeep, I recommend every few years. My practice is every 3 years. Clients come back in and we review what they did. Has anything changed? Anyone married or divorced? Has anyone passed away? Has anyone moved? Those sorts of things. Big events. And I stole this from that Forbes article earlier. I also like mnemonic devices. So if there's been a death, a divorce, a diagnosis, a decline in health, or a decade, and you have not reviewed your plan, you probably should call the lawyer who wrote it or find a new lawyer to blow the dust off it because it's probably gotten a little bit stale. That is the bulk of what I was hoping to get through today. So I'm open for questions. I'm going to briefly leave my contact info up here. I will note I have in bold here that we're moving to 5,200 rings. That move has happened. That's actually Everhart's building in Dublin. So we have the Grandview office where I'm sitting, and then in Dublin, we are at that Rings Road address. You guys can contact Phil or whoever you're working with at Everhart to get a hold of me, or print the slide. If you email or call and just remind me I came to the Everhart lecture, I'd be happy to answer any questions and provide some services. If you don't do that, you could get caught by my receptionist or assistant who will do gatekeeping and go through a formal process. So if you do want to ask something personal, please feel free, consider me a resource, but tell them you came from Everhart. Without that, I'm going to drop the slides. That way I can read the Q&A and answer as much as we can here in what time we have left.
So Jeff, are you able to see the Q&A box?
Yep, I can. If you want me to, unless you
If
want to
you
read
want
them,
to,
I'm
I
happy to
can
take
read
them,
them.
Phil.
I can read them to you if you'd like. Uh,
No, I got it. So I'm just
okay.
going to take these in the order they were submitted. So the first one, and I apologize, I'm both reading and coming up with an answer at the same time. If everyone over 18 should have a plan, this person's son is 22 and going to college. He's got some student loans. He doesn't have anything at all. Wouldn't that person just get his student loans to pay? So a couple things here. One, on the temporary decision, uh, if that son, do we say son? Yeah, if that son is in an accident, because he's over 18, he's 22 now, you have no rights as his parent to make his decision. So on the healthcare side, for instance, if while at college the kid's in an accident and goes to the local university hospital, because he's over 18, you don't have the right to show up, get his medical records, say yes or no to treatment, doctor, et cetera. So the starting point is generally give mom and dad the right to make medical decisions, then go back once the kid gets married, and he probably picks his spouse to do that. Same thing for finances. He may mostly have debt with these student loans, but the reality is he probably has a bank account, perhaps a cell phone, maybe a car, maybe a 529 plan or something. The power of attorney for finance would be great too. And then his will is still important. Yes, if his student loans are higher than his assets, he may not have anything to leave to anyone, but he may have personal physical possessions, whether that's mementos or heirlooms. So I would definitely do all of that. At a minimum, the PLA documents for the young kids make a lot of sense.
And then on the financial side, Jeff, if with federal student loans, they get what's called discharged, so they're forgiven, they're wiped away.
Yeah,
The student's loan, actually even parents plus on too. So you're really not risking creating an estate where the parent would inherit the debt if it was greater than the estate. So there's
yeah,
no risk there.
yeah. Good qualification. I guess I should just add one note since Phil brought it up. For any debt, if the estate has more debt than assets, they do not pass on to the family. Every state has a mechanism by which we wipe out debt. So some people come in and like, I don't want to open a estate because my mom or dad had a ton of credit card debt. That will not pass on to you. There's a priority by which people get paid, starting with the courts and the lawyers, ending with the credit cards. And so debts don't generally go on to the next generation. And so you shouldn't worry about opening a estate or writing a will because there's some debts out there, whether student loan or otherwise. But great clarification, Phil. So
Yeah.
the next one that came in for the durable POA, can you list two people? Yes, pretty much every state allows for co-agents. There are two ways you could structure that. So first, I generally like a choice one followed by choice two. So we have one clear decision maker. And if choice one can't do it, then choice two is the backup. Sometimes we really want to have choice one and two together. So a 1A, 1B scenario. If you do that, you could write the power of attorney to say, either of these people can act independently, which is good. So only one person has to write a check or go to the bank. But if they don't communicate well, I could have two people duplicating the same tasks or working against each other. So you got some risk there. The other way is you could say both people have to do every task. I really don't like that because then two people do have to sign every contract, every check, go to the bank, et cetera. So it's possible to do co, but I would think about picking an A, B, C in order, sort of a tiering system. The next one that came in, can you come on a married couples having assets, title only in one person's name? Should everything be jointly owned? This is sort of personal preference and varies a little bit from state to state. So let's start with automobile since you listed that first. In Ohio, where I'm at, if you're married, cars that are just in one spouse's name, the surviving spouse can walk into the BMV without going to probate or filing the will and take the car out of deceased spouse into surviving spouse. So cars we don't generally worry about for younger people. That may not be the right answer in the state where you're located. So I would want you to confirm that. And then beyond that, it's really up to you. I'd say a lot of married couples title everything jointly and we do survivorship, and that works great. You don't have to, though. You could also make your spouse the beneficiary of things either by POD, TOD, adding a beneficiary on life, et cetera. So it varies a lot depending on your circumstances. You've been married long enough and you have kids together, it's probably joint. If you have blended families, you may not like that. So it's really kind of a fact specific question. Next one, where do you go to establish estate planning? Would essentially be a law office. Yeah, that would be my advice. Like I said, there are some online tools. I would at least talk briefly with a local lawyer and see if it's a good fit for you. Next one, with regards to gift tax, is there a limit for a 501c3 other non-individual? No, you can give an unlimited amount to charity. There are caps on how much you can deduct. So, for instance, and if you give $1 million to your church this year, you can only deduct, I believe it's 50% of your adjusted gross income. So if you earn 200 grand, you can only deduct 100 grand, but it doesn't mean you can't give more to your church or other charity. So there's not a hard cap on it. You also don't pay tax for giving to a charity. The second half is the other non-individual. If you weren't giving to a charity that would allow you to go beyond it, the non-individual would have the same $19,000 limits. If you want to follow up with me on this specifically, who you're thinking, I could clarify that. But I would assume unless there's an exemption for a charity, you're subject to the same gift tax limits. Next one that came in, if you're married, you should have the healthcare will, general POA. But if wills are public knowledge, can you skip writing a will and have a trust instead? So the wills become public when you die and file them. They're not public at the time you write them. So you still do both. The idea for most people is you do a trust and then you have a backup will. The will does potentially two things. One, the will still where you says who raised your kid. So in my case, I don't want to use my will to go through probate. I want to use my Kunkeler family trust, but my will says who raises Nora. She just turned 6. So for 12 more years, I need to say who would raise my daughter. And so my will is still the only place to do that. I can't put that in my trust. And then as a backup, it also says if I forget something and die, just add it to my trust, get it out of the court as fast as possible. So if you forget a car or a bank account, so you generally still do a will, but the public filing part happens when you've died. You do not have to publicly file it in advance of that. So hopefully that clarifies that for you. Someone wants a copy of the recording. Yes, Everhart's going to send that out. That was an easy one. Yeah, something different for a non-citizen spouse. So the estate tax is incredibly small. I don't know the number off the top of my head. It doesn't come up a lot in Central Ohio, but rather than being able to live an unlimited amount of spouse, there's a very low limit you can leave to a non-citizen spouse. If this is a personal issue for you, I definitely think you should talk with a local lawyer where you live and figure out how to best structure your estate, because there are very strict limits on what you can leave to a non-citizen. And so that is important. But not probably the time or place, given we're right at 11, to dig further into that one. A couple more here. I know we're at the limit. And if you do need to drop, folks, I will take no offense if the attendee number starts dropping down, but I just want to answer these last couple ones real quick. If you leave your 401k to your son, does he have to spend it within 10 years? No, he does have to withdraw it out of the 401k account. So under some newer laws called the Secure Act and Secure 2.0, you used to be able to leave a qualified account, so your 401, your IRA, et cetera, to a child, and the child could use their date of birth and say, my expectancy is I'm going to live 50 years. I'm going to withdraw this account over those 50 years. That went away. The IRS is trying to get tax revenue in faster. So now generally, unless there's an exception that they have a disability or they're really young or something, a person who inherits a qualified account has to take the money out of the qualified account during the year you died and the next 10 years. So 11 possible years. That does not mean they have to spend it. So if you have a big 401k, your kid does not have to blow the money in 10 years, but they do have to go out of the 401k into perhaps an investment account or a savings account or a down payment on a house or something. Average cost to set up a trust, really hard to say without the specifics. We have sort of some fee schedules. And like I said, most lawyers will give you a free consult. I'd say as a guess, you're probably paying at least a couple thousand, hopefully not more than a few thousand. I really don't know enough to give you much more specific than that. And then the last one that's in here, and we're not going to take any more because like I said, I'm up against the time. Is a trust the best option if you have multiple properties and only 2 kids? Would both get half of the properties and have to agree to sell, or could they keep them? So kind of fact specific. I'd say often, rather than having multiple decision makers, one of the benefits of a trust is one person's in charge of it. So I don't need both kids to agree as to the realtor or fixing it up. If these properties are sort of the family business and you want to inherit, it's so totally possible. You could leave the properties half to each kid and they could continue on this operation. Statistically, very few businesses of any sort, whether rental or operating, make it from parents to kids, and then even fewer from kids to grandkids, and almost none make it from grandkids to great grandkids. But it's what you want. I have plenty of folks who do say, I want these 2 kids to have to work together to either make widgets or rent properties or whatever it is that you do. So kind of fact specific. But because there's multiple properties involved, that would probably be an expensive one to go through probate. So a trust is probably the answer, but would be happy to talk in more detail if it would be helpful to you. So With all that, I'm 2 minutes late, 5 if I look at that clock. So I'm going to give it back to Phil.
Thanks, Jeff. I appreciate it. I know it's all dense of everything. So just people are asking about the slides and everything. If the recording and the slides will be emailed out tomorrow. So don't worry about that. If you have the invitation here, and if it doesn't get emailed to you, just check everhardadvisors.com/EAU. And then just personally, real fast, Jeff did my personal estate work. Highly recommend him. I work in this stuff all the time, so I have a good idea of it, but my wife does not. And she walked away saying that she understood it significantly better. So can't recommend Jeff enough. Think it'd be a great Carlisle Patch, and just a great office to say that if you have some questions or need some work done, I would send people that way. So Jeff, appreciate your expertise. Thank you everybody for jumping on. And if you have any questions, feel free to follow up with us and have a great day.